Welcome, business law students. We previously spoke about courts, their authority, jurisdiction. Now, let's talk about what a trial looks like. Once you get into court, let's just take it from birth to the end, from the beginning to appeal, and let's see what you can do. All right, they're basically, let me just share real quick. One easy way to think of trial or litigation is a better word because trial is one section, litigation is pre-trial, trial, and post-trial. Let's talk about what happens in each. So here's just an example. Another company breaches their contract. You paid them money to provide goods. They didn't do it. Well, that's a breach of contract. So you go hire a lawyer. The lawyer files a complaint in the court and then has to serve that complaint or give a copy of that complaint to the defendant, who in turn files an answer with the court. After that, they have what we call pre-trial discovery, which we'll get into. And there might be motions, pre-trial conference, and everything. And then we get up to trial. If it goes against somebody, they then might appeal after this, which is not in the picture, not in the diagram. Just a couple things or a few things to know when you hire an attorney. There are various ways you can do it. Sometimes there's a fixed fee. Uh, and like, okay, I'm doing a basic will. So you're just doing a will. So you go hire an attorney, you might say, oh, it's $2,000 just for a will, if there's not too many changes to the form. Hourly fee, that is standard. And you'll find in this part of the country, you're going to see, sorry, spelling error. Um, well, in the US, for example, you'll see rates from maybe $200 an hour to $5,000 an hour, depending on the attorney, their experience, your trial, not trial, et cetera, et cetera. And frankly, usually the um, bigger the case, the more expensive hourly charge, one would think, but really it usually has to do with who has the most money to pay. Um, Sometimes you'll see contingency fees. You might see advertisements on TV, and these guys say you don't pay anything if you win. Well, you'll still have to pay costs, like if they take depositions, but you don't have to pay attorney's fees, but they get a big portion of your money, anywhere from 30 to 50%, depending on the state and the rules and et cetera. Um, that's often for things like personal injury lawsuits, people that are not a big corporation suing somebody else. So you might see that. That's how they make their money. Now, once we get in a court, what rules do we follow? Well, back in, I believe, chapter one, we talked about, and maybe it wasn't one, but in any event, we talked about a distinction between substantive rules and procedural rules. You hit me with your car. It was an accident. Well, the substantive law is I can sue you because you can't be negligent. That's the substantive law, or I can sue you. But where do I go? What court do I file it in? How do I go to trial, etc.? Those are known as procedural rules. So the federal court system has adopted federal rules of civil procedure they follow, and each state of the U.S. has adopted very similar state rules of civil procedure that usually are very close. On top of that, you'll see local trial court slash district court slash circuit court rules that that like when can you file a motion, when do you have to respond, et cetera, et cetera. So let's go back to the phases we taught pre-trial. Um, we file the pleadings we already talked about, a complaint answer. We will gather evidence and we can file additional motions. Well, first, what are the first two? A complaint and an answer. Person starting it is known usually as the plaintiff, and they will sue the defendant. So you have to have certain things in it, like the jurisdiction of the court. We've talked about that. Yes, I'm filing it in the proper court because the person lives here and this traffic accident happened here in this state and this county. By legal theory, you just can't go to court and say, I sue somebody. Every law firm has to sort of fit into a box, a descriptive box. Like at one point, we talked about jury instructions, and you have to check the box and do what, uh, like negligence. They have a duty, they violated a duty, blah, blah, blah. They have to prove those four things. That'll be called your legal theory of the case, negligence. And what's your requested remedy? Damages. I had doctors' costs, blah, blah, blah. They do an answer. They'll either admit or deny every paragraph that was in your complaint. They also can do affirmative defenses, which are similar to the check the box that you had to do as the plaintiff. The defendant sort of has to check the box and say, wait a minute, I have this legal defense and we're going to be able to prove A, B, C, D. And they'll have a jury instruction about that. And then the jury and or the judge determines, were they able to check the box? Did they give us sufficient evidence to prove their defense? And sometimes counterclaims. If two companies are suing each other, breach of contract, and one says, well, you gave me crappy goods, the other said, I paid you, you should provide the goods, and they were bad, or, they can each sue each other for damages. That's known as a counterclaim. Let's show you an example. These are just a couple of forms I pulled out. See if I can make them bigger for you. I apologize. This is just like this is a California form, and this shows you, um, see, it starts, these are the facts, I'm here, these are who the people are, and then it just continues for pages. Here's a form answer. This happens to be out of California. And basically you have the court up here, same as over here, um, and who the parties are, what case number, which the court assigns. This is my answer. I comes down defendant, and I'm saying I agree or disagree with their paragraph one. I agree or disagree with their number two. So paragraph number two. Now, you can't just file it as a plaintiff. You got to go serve it. You got to find the person. So in addition to the complaint, you'll do a summons, and you'll either get a private process server or maybe a sheriff in a county, and they find the person. Alternatively, you might use certified mail or an expedited delivery service like UPS or FedEx, something like that, where it proves the person signed for it. We already talked about process server public notification. Let's say that uh, your worthless ex-husband um, left you and uh, you can't find him. He has disappeared and you want to get a divorce. Well, you can, in that type of a situation, you can actually file in a newspaper. It's called public notification. All right. Then the defendant's attorney, if he gets served, then his attorney files an entry appearance. Hey, I'm Joe Schmo, and I'm going to represent this defendant. Or he just files the complaint and makes his appearance that way. Either one. Now, we've served the defendant. Now both parties have the right to conduct what's known as discovery, pretrial discovery on each other, and find out facts that are relevant to the case or reasonably calculated to lead to the discovery of admissible evidence. You can't just ask anything. It has to really be related to the case. So first, you can take depositions of witnesses or parties, plaintiffs or defendants, and either you can use them at trial, or if the witness is not available at trial, you can use it to impeach or discredit them if they've changed their testimony. You don't do that in court. You usually do it in a law firm conference room. There's a court reporter, but not a judge. So they swear on an oath, and it's similar to what you've seen in trial. Both attorneys get their chance talking to each other. Next, interrogatories. That's a fancy schmancy word for questions. Your attorney gets to send questions. Then their attorney gets to sign back answers. That doesn't go to witnesses, that goes to the parties in the lawsuit. And they usually have to sign them written so that you can later say, this is an admission. You can also do request for admission because remember when I talked about check the box on causes of action? Well, the judge and the attorneys don't want to waste their time if there's really only one element in dispute and the other three, both parties agree. Well, were the goods crappy or not? That's the only thing left. We know there's a contract. We know money was paid, blah, blah, blah. So we might do a request for admissions to the other party, admit the goods were sent, admit they were paid for, blah, 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 and they should admit it. So when you get to trial, the only thing you're talking about is, were the goods crappy or not? And you don't waste time on the other. Let's look at some videos real quickly of these different forms of discovery. And I don't believe they're very long. I wouldn't force you to go through them. So bear with me. Thank you for your patience. No, we don't want ChatGPT. All right, I will change that, but if you can, you get the gist of it. Um, look at the textbook, and that will explain it. Again, it's just questions, and I put the prompt on there. Your professor got caught doing ChatGPT, and I do that sometimes just to look up videos. Amazing. So don't worry, you're not the only one that uses ChatGPT. All right, let me share now that I've got the video. Oops. Sorry, I want to make sure you can hear the video. That would probably be helpful, wouldn't it?
More students are choosing Themis and UWorld over the competition. We've combined.
In this video, we will discuss requests for admission. In a request for admission, a party is basically saying, look, admit this is true now, so we don't have to waste time proving it later. Requests for admission are part of the discovery process where parties to a civil litigation obtain and disclose information prior to trial. Requests for admission are special because their primary purpose is to save time. They're intended to speed up the litigation. In a request for admission, one party to a civil litigation asks the other party to admit certain things are true. The other party can be asked to admit facts, the application of law to facts, and the genuineness of documents. So let's say we have David and we have Patty. And Patty is suing David for negligence. Patty is alleging that on February 2nd, David crashed his blue car into her car. Furthermore, she alleges that on February 3rd, David sent her an email from his davidzz@yahoo.com account. And in this email, David admitted that he crashed into her car and that he was very sleepy at the time. Now, there are a bunch of things that Patty's going to want to prove at trial. She'll want to prove that David was driving the blue car. She'll probably want to prove that David sent that email, and all of this is going to take time. Requests for admission could speed things up for her. First, she could ask David to admit that he was driving that blue car on February 2nd. If it's true, David will probably have to admit that. He'll have to say, yes, it's true, I was driving that blue car. Otherwise, David will deny the request for admission, and Patty will have to prove it at trial. Next, Patty may ask David to admit that his email address is davidzz@yahoo.com. And she could also ask David to admit that he sent that email on February 3rd. If David admits that he was driving the blue car and that he sent that email on February 3rd, well, good for Patty, and good for our legal system, because now Patty doesn't have to prove this at trial. It's already admitted to be true. If you'd like to discuss requests for admission or any...
All right, let's watch another short video that talks about depositions.
The que-
Now, this is from one of my favorite movies where they are, the lawyers are defending a arrogant surgeon, and they're hoping he's humble and sorry, contrite. It wasn't all my fault, blah, blah, blah. Right? That's the basis. So he he's being deposed, and by the attorneys for a girl, a lady upon whom he operated, and took her reproductive organs out, which didn't need to be done. And she was younger, wanted kids, blah, blah, blah. You can watch the movie and see why. It's really good. But in any event, I will now show you the video of probably the worst deposition from the defendant's perspective you will ever see.
question is, do I have a God complex?
Dr. Kessler says yes.
Which makes me wonder if this lawyer has any idea as to the kind of grades one has to receive in college to be accepted at a top medical school. If you have the vaguest clue as to how talented someone has to be to lead a surgical team. I have an MD from Harvard. I am board certified in cardiothoracic medicine and trauma surgery. I have been awarded citations from 7 different medical boards in New England, and I am never, ever sick at sea. So I ask you, when someone goes into that chapel and they fall on their knees and they pray to God that their wife doesn't miscarry, or that their daughter doesn't bleed to death, or that their mother doesn't suffer acute neural trauma from post-operative shock, who do you think they're praying to? Now, you go ahead and read your Bible, Dennis, and you go to your church, and with any luck you might win the annual raffle. But if you're looking for God, he was in operating room number 2 on November 17th, and he doesn't like to be second-guessed. You ask me if I have a God complex? Let me tell you something. I am God.
Yikes. So that is, whoo, that's the movie that, again, I like the movie, but wow, that is like a lawyer's nightmare if you have a client like that. Anyway, good little movie. You might enjoy it. Now, uh, let's move back to, we've done the different discovery, interrogatories, document request. I request, for example, give me her medical records, hospital. Request for admission, we talked, deposition, we talked about. So then you can file various motions. I'll let you read these on your own, but 2 are the most important. The first is motion to dismiss. You remember at various times we've talked about 2 people in a car crash and they live in different states. Well, the guy, I think it was New Jersey, New York, the guy that lives in New Jersey might tell a New York court, wait a minute, motion to dismiss. Yeah, there was a car crash, but it wasn't in New York, it was in New Jersey, and I live in New Jersey. So he would file a motion to dismiss based on lack of personal jurisdiction. The court doesn't have authority, okay? Finally, motion for summary judgment is fairly common. Once all the evidence is in, one party can say, here's all the evidence. The material facts, what does that mean? Doesn't have something to do with cloth and making dresses or suits. The material facts are those that are relevant to the case. The material facts are undisputed. And we have a right to win as a matter of law. And then the judge can actually grant or deny summary judgment, and people don't have to go to trial. If summary judgment motion doesn't work, you go towards trial. Attorneys will have a pre-trial conference. And then you just sit down and basically, hey, how long is this trial going to take? The judge asks you, you fill out a form. How many witnesses are you going to have? Who are they? What kind of documents are coming in? Blah, blah, blah. And basically, what are the issues still in dispute? So that's a pretrial conference your attorneys will have with the judge, with the other sides. Then we go to trial. Jury selection called voir dire, depending on where you are in the country. And you might have seen this on movies or TV, but the attorneys actually have limited versions or limited opportunities to kick out potential jurors. So if you're a registered voter or something like that, you might get a letter says you got to come down. And maybe if I need a jury of 10, I'll pull 20, 30 people to courtroom, call up one at a time. The attorneys can question them. And then they might have 3, 4, 5, 6, depending on the system, that they can just kick out until you have a jury, 6, 10, 12, depending on the system. So let's watch a little YouTube video. Come on now.
All right, Mr. Flintine, let me ask you this.
I really do appreciate your patience while we go back and forth. And again, and one of you has a quick way to do this, email your professor. This is a little rough. Trigger warning. So if, yeah, it's about a guy that represents a really bad guy and inappropriate child stuff, etc. So if this, you're sensitive, seriously, please do not watch. Please skip right over this part. But it really is in depth about a lawyer relying on a consultant, I believe, or another lawyer about how to select certain jurors.
All right, Mr. Flintine, let me ask you this. Do you think as a juror, you would be able to set aside any prior opinion you might hold about the savings and loan industry? That was a question, sir.
What? Do I like bankers?
Your Honor, may I have a minute, please, to confer with my colleagues?
You may.
Dump 'em. While you're at it, let's get rid of number 4 and 6. And I'd say lose number 12, except the prosecutor's gonna fuck up and do it for us.
Number 6. You're kidding, right? She's my first choice.
She's my first pass.
And 4? With the dreadlocks. That's crazy. That's a defendant's juror if I ever saw one.
Did you see his shoes?
Look, kid. Maybe down in Florida, you are the next big thing. This is New York, Manhattan. We're not squeezing oranges here.
He polishes those shoes every night. He makes his own clothes. He may look like a brother with an attitude to you, but I see a man with a shotgun under his bed. And woe betide the creature who steps into his garden. And number 6, your favorite, she's damaged goods.
She's a Catholic school teacher. Believes in human frailty?
No, there's something missing from her. She's wrong. She wants on this jury. Somebody hurt her and she wants revenge.
How the hell do you know that?
I don't know.
Look, either you put a stop to this happy horse shit or I walk. Walk. All right, here's the deal. I lose with your jury, you do the explaining.
Your Honor, may I continue?
Okay, so that, and I apologize, the language is a little rough, but essentially, they are talking about kicking people off because they think they'll go the opposite way of their client. Very common. Now, there are some restrictions. And that is, for example, that one can't choose someone to have a racially biased jury. That's a constitutional protection. I think it's a great idea. One guy argued about a jury of his peers, and I can't remember what race he was, white, black, whatever. But the prosecution kicked out all the people of the same race as the defendant, and it went out to Supreme Court. Supreme Court said, I don't think so. You can't just kick people out for racial reasons because it results in an unfair jury. So love that that court finding. Okay, let's go back to the slides. Once we get to trial, and I think you guys have seen 100 cases about trials, but both attorneys get up and say, this case is about, and the other one says, no, this case is about blah. So the plaintiff starts, then the defendant goes, then both attorneys get back up and do closing arguments. Then the judge gives jury instructions to the jury. Remember what jury instructions are? They're literally the law. Says, here's the law. You have heard the evidence. Does it check the boxes on this law, yes or no? And then they have the verdict. Now, sometimes a judge will reach the decision instead of a jury based on if that's what both sides choose, but often there is a jury involved. Plaintiff, they do direct, cross, redirect, recross. So if I represent the plaintiff, I will ask these questions. The defendant gets up and does cross. I might be able to redirect. Wait a minute, you said on cross this, but you meant this. And then they will recross my redirect, and that's it. So some of you may have seen this. I'll let you watch it, but basically, you can't handle the truth on A Few Good Men. I'll let you watch that movie clip, but it's pretty interesting. So once you examine a witness, you can't just say anything. You really can only talk about evidence that is relevant to the case. What's relevant? Largely, go back to the jury instructions. They have to do with one of those elements. Hearsay is not permitted. I'm not going to test you on the hearsay rule, but look it up in the textbook. And to a certain extent, you have to have the person that said it or a document in the court. Can't say, well, Mary Jane told me this. Bunch of exceptions. Person had died. It's from the opposing side, blah, blah, blah. But that's what the hearsay. Oh, just someone said it outside of court. To the extent you can, you try to get it into court. What's an expert witness? A lay witness. Lay witness is just a person who, I saw the car crash, so they're called as a witness. Expert witness might be an accident reconstruction professional who says, no, I've been doing this for 40 years, and the guy was speeding before he hit Professor Litz. Professor Litz may have deserved it, but he was speeding. So that would be an expert witness because they can give opinions and conclusions. Right. Goes to the jury, jury comes back. You don't like it, you can ask the judge for a motion for new trial or motion JNOV. It's in the case book. You don't like what the judge does, boom, you appeal. Sometimes it has to be a different attorney because sometimes if your case is complicated enough, you go get an attorney that specializes in appeals. Well, I got to go through the steps quickly, but for example, then you have to go back to the court clerk down on the trial and say, I need all exhibits, all testimony written down, blah, blah, blah. And that's going to be the record on appeal. Remember, that's what appellate judges will review. They're not going to retry the case. They're not going to have witnesses. They're not going to do this. They will look at the record in almost every instance. There seems to be exceptions to everything, but generally. So the attorney that is appealing files his brief. Then the other side can answer, and this is at the appellate court, they're filing these. And then you might be able to file an answer brief, and then the court reviews the case, and boom, will issue their opinion. Now, appellate courts, what can they do? Well, they can affirm a trial court's decision. Yeah, they were right. They can reverse a trial court's decision. No, they were wrong. Or sometimes they can remand to the trial court for further proceedings because they might say, hey, you didn't ask about this and that would have made the difference. So they just say, go back and have a mini trial only on that and then send us the record. Or the appellate court can actually affirm in part, reverse part. Well, we agree with this part of the judgment, not that part. And sometimes in extreme situations, they can actually modify the judgment. Okay. Let's see if I can copy this. And then if you have a judgment and the time for appeal has passed, that doesn't mean you get the money. That means, like, if someone has no, let's say someone has no assets, well, what are you going to do? You can't go get anything. But if you sue a rich person or a corporation, they'll have assets. Let's see if this will explain that situation a little better. And the video quality for some reason is not coming through very well this week, so I apologize.
As a foreclosure defense attorney, this is sweet justice.
Only on Wink tonight, the tables are turned. Instead of Bank of America foreclosing on a home, a homeowner has deputies foreclose on the bank.
Bank of America filed foreclosure papers on a homeowner who didn't owe a dime. They paid for their house with cash.
Renee Stoll live at the Bank of America branch on Davis Boulevard in Naples with this story you'll see only on Wink tonight.
This is about a family who fought back and won. Their foreclosure nightmare started when they bought a house in the Golden Gate Estates owned by Bank of America. Like you said, they paid cash, so they never had a mortgage. Well, Bank of America fouled it up somewhere along the lines and actually tried to foreclose on the family. And what happened today, you're just going to have to see to believe. Movers, a truck, and an armed deputy, all while a nervous homeowner stands by and waits. This is normally what you'd see when a person's being foreclosed on and their property seized by a bank. But today, it's the other way around.
They've ignored our calls, ignored our letters. Legally, this is the next step to get my clients compensated.
A Collier County judge said Bank of America had to pay Maureen Nairges and her husband's legal fees after the bank tried to foreclose on their Golden Gate Estates property, but they paid cash. The courts agreed they never had a mortgage to begin with. After more than 5 months, the bank still hadn't paid up. So the homeowner's attorney did just what the bank would do to get their money: seize their assets.
I instructed the deputy to go in and take desks, computers, copiers, filing cabinets, including cash in the drawers.
Outside the bank, several deputies stood by with movers ready to start hauling out the bank's office supplies and furniture. Inside, the homeowner's attorney was locked out of the bank manager's office by deputies, while the bank manager tried to figure out what to do.
He was visibly shaken. Having two sheriff's deputies sitting across your desk and a lawyer standing up behind them, demanding whatever assets are in the bank, it can be intimidating. But so is having your home foreclosed on when it wasn't right.
After about an hour, the bank finally cut a check.
As a foreclosure defense attorney, this is sweet justice, because this is a symptom of a larger problem.
Now the homeowners.
All right, so the beauty there was usually it is a large corporation suing the little guy and then trying to seize his bank account, for example, or his house or whatever. People miss a loan, a few payments on their house, and I understand, but the bank gets a judgment and seizes their house and sells it. And this was beautiful because this is a case where the bank did something wrong. The homeowner got a judgment against the bank and then said, okay, got a sheriff's order and marched into the bank. It says, I'm taking your bank, the assets in here. And I wish I would pay to have seen the manager's face after ignoring these people for all this time. Anyway, that's this week. I hope you found it mildly interesting, and we will see you at our next lecture. Thanks.